Hi friends, in this video we are going to deal with the important judgment titled as GAUTAM NAVLAKHA versus National Investigation Agency pronounced on 12th May 2021. This judgment is about the power under section 167 of Code of Criminal Procedure 1973 can also be exercised by court superior to the magistrate. To know about the synopsis of the case, please watch the video fully. The facts of the case would be that Gautam, the jailed activist, came to be arrested from his residence in Delhi on 28 August 2018. The accused filed a writ of habeas corpus in the Delhi High Court, which ordered for house arrest. The order of house arrest was extended. After crossing many legal hurdles, the accused finally moved for default bail, for which the accused included the period of 34 days of house arrest. The NIA special court before which the application for default bail was moved rejected the application. The accused preferred an appeal which was dismissed, against which the accused filed appeal before the Supreme Court. There were many contentions that were touched upon by the learned counsel for the accused, but our focus here would be on the contention that the order passed by Delhi High Court is not one passed under section 167 of the CrPC, for the reason that what CrPC contemplates is an order passed by a magistrate. So there were many issues dealt with before the Supreme Court, but the focal issue would be whether superior courts, including a high court, can exercise power under section 167 of CrPC, or in other words, whether a court other than a magistrate can order remand under section 167 of CrPC. Dismissing appeal filed by Gautam seeking for default bail, the Supreme Court has held that ordinarily the magistrate is the original court which would exercise power to remand under section 167 of CrPC. But the power under section 167 could also be exercised by courts which are superior to the magistrate. The Supreme Court further held that such custody ordered by superior courts would be the custody for the purpose of calculating the period within which the charge sheet must be filed, failing which the accused acquires the statutory right to default bail. The Supreme Court has attained this answer by way of two illustrations. The one is that a magistrate orders a remand under section 167, and at the same time he also rejects the application for bail. The accused approaches the High Court, which reverses the order and grants him bail. This order is challenged before the apex court, which reverses the order granting bail. The original order passed by the magistrate is revived. Since assuming that the period of 15 days is over and police custody is not permissible, he is sent back to judicial custody. Equally, if he was already in judicial custody, the order granting judicial custody is revived. Let us assume in the illustration that the accused was in custody only for a period of 10 days, and after the order passed by this court and the accused who spent another 80 days, he completes, in other words, a total period of custody of 90 days, adding the period of custody he suffered consequent upon the remand by the magistrate. That is, by piecing up these broken periods of custody, the statutory period of 90 days entitling the accused to default bail is reached. Can it be said that the order of this court granting custody should not be taken into consideration for calculating the period of 90 days, upon completion of which the accused can set up a case for default bail? We would think that the mere fact is that it is the apex court which exercised the power to remand, which was wrongly appreciated by the High Court in the illustration, would not detract from the custody being authorized under section 167. Another illustration is that after ordering remand initially for a period of 15 days, of which 10 days is by way of police custody and 5 days by way of judicial custody, the magistrate enlarges accused on bail. The High Court interferes with the order granting bail. Resultantly, the person who has come out of jail custody is put back into the judicial custody or jail custody. The order granting custody by the High Court cannot be treated as one which is not anchored in section 167. Therefore, we would think that though the power is vested with the magistrate to order remand by way of appropriate jurisdiction exercised by the superior courts, the power under section 167 could also be exercised by courts which are superior to the magistrate. Hi friends, to conclude, in this video we have seen that the power under section 167 of Code of Criminal Procedure 1973 can also be exercised by courts superior to the magistrate as per GAUTAM NAVLAKHA versus National Investigation Agency case. In the next video, I will see you with yet another case synopsis. Until then, I take leave of you. Bye.